of Virgin Aviation TM Ltd and Alaska Airlines.
Morning, Mr. Weiselberg.
My lords, my lady, yes. My name is Weiselberg and I am here with Edward Ho on behalf of the Appellant Alaska and Daniel Toledano KC and Joshua Crow appear the respondent Virgin. And subject to the court, we've divided time at this hearing as follows. We propose on this side of the room to make submissions until about 12:30. Then,
Sorry, you're going to have to speak up a bit.
I'm sorry,
There's
my lord.
quite a lot of background noise.
We have opened the window, or
Okay.
rather, the window has been opened on grounds of heat.
Okay.
But if the court thinks
No,
it
it's
is too noisy,
all right at the moment, but sometimes we get a lot of trundling going on outside.
I will speak louder. Thank you.
Keep going.
My lord, subject to the court, we have proposed that I finish my submissions, or that this side of the court finishes our submissions round about 12:30. Mr. Toledano will then respond, with Mr. Crow or not, until about 3:45, and then we will have the remainder of the day to make reply submissions.
Right. And have you considered asking your juniors to make part of the argument?
I have, my lord, and Mr. Ho will be making submissions in relation to grounds 2 and 3.
Thank you.
In relation to ground 1, which I will deal with, I will take my submissions in 8 parts. The first part that I wish to deal with is by way of introduction. And we submitted to the judge, and submitted again in writing to this court, and will submit orally to this court today, that in truth this is a relatively straightforward case of contractual construction. We say...
Not worthy of a judgment so long, then.
Absolutely, my lord. With respect to the judge, we would say that the judgment itself is long on exposition of submission, but short on reasoning on the crucial questions. If I can be excused putting it in relatively high-octane terms, I would say the judge lost the wood for the trees. We say that Alaska's construction is one that is supported by the language the parties used in the TMLA, the Trademark and License Agreement. It's also supported by the admissible factual matrix and also by considerations of business common sense. We say our submission is neither complex nor convoluted, those being Virgin's accusations against us. Rather, we say clause 3.7, which lies at the heart of this appeal, is a readily understandable clause on its face, which was a product of a particular regulatory regime, and it means what we say it means. And what do I mean by that? Well, in a nutshell, we say the clause provides that no royalties are payable if there is no use of the names or marks. We say that's the effect of clause 3.7. Clause 3.7 is a trumping or overriding provision. It expressly overrides certain obligations, see clause 3.6, where the words, a direct reference to clause 3.7 appears, but it also has the same effect of overriding or trumping the minimum royalty provisions contained in clauses 8.1 and 8.6.
And commercially, you say Virgin can terminate if it wants, if there's no use made of the marks, and that's how it gets its money.
Absolutely. It can make the choice in the regulatory regime that exists whether it wants to terminate, whether it wants to exploit its brand and marks outside the current environment, where there is non-material use or the use of the brand has dropped below a material level, Virgin have the right to terminate. And in the case of no use, we similarly say Virgin has the right to terminate. In contrast, we say that Virgin's case, as presented to the judge and then to this court, requires a large amount of relatively arcane hair splitting. That approach is used to the language that the parties used. It is also used in relation to the commercial realities that underlay the conclusion of first the 2007 TMLA and then the 2014 TMLA. And we say Virgin's approach is not justified by any of the applicable approaches to contractual construction. It's wrong on the language of the clause, it's wrong on the language of the agreement, and it's wrong on the factual matrix and commercial common sense. And as I've already said to my lord, the Master of the Rolls, we say that the judge adopted a fundamentally wrong approach towards the construction. He did that in a judgment that is long on repeating arguments, but short, and we say deficient, on analysis. And when one looks at the operative parts of this judgment, which start at paragraph 150, and there's no need to turn it up, the court will have it well in mind, and for the reference it's core 7, page 135. If the court is using the electronic bundles, that's 138. The core operative part of the judgment runs to just 4 pages. And as I hope to show during the course of my submissions this morning, the process by which he reached his conclusion was wrong, and the conclusion that he reached was wrong. Indeed, it is notable that despite the absence of any respondent's notice, Virgin do very little in their skeleton to seek to support the approach actually adopted by the judge. Overall, however, we submit, and this is again by way of introduction, that a focus on the words of the contract is likely to provide the answer to this appeal. The language of the contract is key. Now, as the court knows,
one of your 8 parts is going to be to look at the contract, is it?
it is, my lord.
Remarkable.
Both clause 3.7 and other clauses.
Yes. Good.
So, my lord, then I go to where am I going next and how am I structuring my submissions? My second part of my submission, I'm going to look very briefly at the law. Very, very briefly. Third, I will look at clause 3.7. Fourth, I will look at the wider contractual context. Fifth, I will look at issues of purpose and factual matrix. Sixth, I will look at issues of commercial common sense. 7, I will look at Virgin's 4 scenarios. No, I'm sorry, I got that wrong. Fourth, I will look at the contractual context. Fifth, I will look at scenarios. 6, I will look at the purpose of clause 3.7 and factual matrix. 7, I will look at business common sense. And 8, I'll make a few concluding remarks. In relation to the...
I'm afraid with the rejigging, I got lost.
I'm sorry, my lord. So, third, 3.7.
Yeah.
Fourth, contractual context. Fifth, Virgin scenarios. 6, the purpose of clause 3.7 and factual matrix. 7, business common sense. And then 8, some concluding remarks. I apologise.
And you will look at the judge's reasoning and tell us why he was completely wrong. Will you?
Absolutely.
Yes.
Absolutely. In the context of those submissions, I will look at what the judge has said.
Yeah. Okay.
In relation to the law, my lord, there are 3 areas where authority may assist. I'm going to deal with 2 now and return to 1 later in my submissions. The first one I want to deal with is briefly to make submissions as to the approach that this court should adopt to questions of contractual construction. On that topic, there is no real difference between the parties, and it is unlikely that anything that I will say will assist, ultimately, the decision that the court will make. What the court has, though, in the bundles, is Rainy Sky in the authorities bundle. That's authorities bundle 4, tab 1, page 111, in PDF, page 112. And then your lordships and your ladyship have Arnold and Britton and Wood and Capita in the judge's judgment, paragraph 69 to 71. That's core bundle 7, page 105, or page 108 in the PDF. I'm not going to take the court to those judgments. I'm going to make 3 short points in relation to them. First, I make the point that interpretation is a unitary exercise, but the process is an iterative one. What does that mean? It means checking suggested interpretations against the provisions of the contract and its commercial consequences. And that's Rainy Sky at 28, Wood at 11 and 12. That's the first point. The second point is that the starting point is to read the language in dispute and the relevant parts of the contract that provide context. That's Wood at 12.
I thought Wood says it doesn't matter which way you start.
That's the next point. Third, after that, it doesn't matter whether the more detailed analysis begins with factual background and the implications of the rival constructions, or a close examination of the relevant language. So the question is, set it in context. What am I in general doing? And then you have to decide what to do. And that's Wood at 12. But standing back for both points 2 and 3, I would submit that it is important not to lose the wood for the trees.
Well, that's not a pun, I suppose.
No.
But you do have to decide if the words are ambiguous, don't you, before you get into some of the analysis. I mean, there's an awful lot of sort of faux analysis in these cases. The truth is, you have to look at the words. Whether you do it first or second doesn't matter. You have to look at the background, but you have to look at the words and be satisfied they're ambiguous before you start overlaying a lot of other factors, don't you?
Well, that may be the case, my lord. Absolutely. Certainly, in this case, we would say the court can just look at the words and decide what the words mean.
So you say they're not ambiguous?
No.
I think Mr. Toledano probably says the same.
I do.
Yeah. Lovely. Well, that's the stuff of interpretation cases. But let's call it contractual interpretation, not contractual construction,
Very good.
which is a term I hate. It's in statutory construction. Good.
So, my lords, my lady, the second point that I want to make relates to the judge's approach to business common sense.
Yeah.
And the only case that I want to show the court on that is the Bank of Nova Scotia case. As the court knows, we say that the judge erred in focusing on the purpose of Virgin, the licensor, and not on Virgin America or Alaska as the licensee. And we rely on the Bank of Nova Scotia case, which is an authorities bundle, tab 1, page 1. We set it out, or the material passage in our skeleton argument.
Sorry, which paragraph of your skeleton?
It's paragraph 61, my lord. And the court there has the case. The reference for it is in Authorities 1, page 1, or PDF, page 2. I'm afraid the reference to page 890 is wrong. It should be 870. The facts of the case don't ultimately matter. It was a case concerning a contract of marine insurance. And Lord Justice May delivered a judgment on behalf of the court. Lord Justice Ralph Gibson and Lord Justice Bingham agreed. And the principle for which we cite the case is unlikely to be contentious. We cite it on the basis of the dictum set out there. It is nonetheless important in attributing a purpose to a commercial transaction to be sure that it is the purpose of both parties and not just one. if the purpose of the transaction is seen through the eyes of one party only, an unbalanced view of the transaction may result. And that is the principle, and I will come to look at the underlying material in relation to the judge's conclusion in due course.
So it's 870.
870, my lord, which is page 54 of the PDF.
I think you'll find it's 55 of the electronic, but anyway.
Oh, I'm sorry, yes, my lord, 55. And it's the highlighted passage G to H.
Yeah, got it. I mean, it's hardly earth-shattering.
No, it's not, my lord. And I don't think I need to say much more about it than I've just said.
Yeah.
The third area where authority may come into play relates to surplusage, but I'm going to deal with the surplusage arguments when we come to look at the way in which Virgin and the judge approach that particular problem. So that's the second area of my submissions. The third area relates to the words used in the TMLA, in particular clause 3.7. If one goes, please, to the agreement itself, it's in the core bundle, tab 12, page 200 or page 203 in the PDF. One starts by looking at the parties. We see that the claimant is the licensor, the defendant is the user, then the defendant was called Virgin America, now it's called Alaska Airlines. And then the third party, VEL, is the beneficial owner of the goodwill associated with the word Virgin. Then one looks at the background. One sees recital A setting out the nature of VEL's interest. One sees in background B reference to two particular agreements, its recognition of two material agreements and a third amendment. The existing license is the 4th of February 2005 document. That's supplementary bundle 1, page 4 in the PDF, page 1 in the hard copy. Then there's a reference to an amendment on the 9th of April 2007. That's also in the supplementary bundle. That's supplementary bundle tab 8, page 163 or page 166 in the PDF. And then there's a further amendment on the 1st of March 2013. That's not in the bundle, that's not material. Then recital D, the parties agree that conditional upon and with effect from the effective date, this licence amends and restates the existing licence. Then at page 203 of the bundle, page 206 of the PDF, the court will note the references to airline rights, airline royalties, and gross sales. Airline rights is the rights granted by the licensor to the user pursuant to clause 3. Airline royalties means the royalty payments payable by the user in consideration for the grant of airline rights, as more particularly described in clause 8.1. And then gross sales, which become relevant as we will see in due course, means the total amount received by the user, its affiliates and or its sub-licensees and assignees in connection with the carrying on of the licensed activities, exclusive of various things. But for present purposes, if we can cut on, please, to clause 3, which is at page 206 of the hard copy, page 209 of the PDF. The clause is entitled Grant of Airline Rights. No need to look at it, but the court will note that the headings of the licence and any headings in any clauses are for the purpose of convenience only. That's clause 19.1. But one looks at clause 3.1 in consideration of the payment of airline royalties to the licensor by the user. The licensor grants to the user the right, and then it sets out various rights to use the marks, 3.1.1, to carry on the licensed activities only under the trading or business names Virgin America Airways, Virgin America Cargo, and any other name using the word Virgin. 3.1.3, to do and authorise the doing of all acts, the doing which is restricted by copyright, etc., etc. I'm interested in going then to clause 3.7, which is at page 208 of the hard copy bundle, page 211 of the PDF. And the opening words, we say, are critical, notwithstanding any other provision of this licence. We say it's an obvious point, but those words are expressly a trumping or overriding provision. Those words cannot be circumvented, and what comes next governs the agreement. Those words serve to emphasise that they override anything else in the agreement.
Well, forgive me, they're overriding words, but that doesn't mean you ignore everything else in the agreement.
Absolutely.
Your starting point must be to try and construe everything together.
Exactly.
Which is perhaps why you do need to look at. See what I mean?
Absolutely.
You do need to look at clause 3.3, 3.6, and 3.7. I mean, you need to look at the whole of 3 together.
I completely accept
What
that,
I think my Lord's saying.
and I'm going to come back to 3.6
Okay.
in a moment.
Good.
I'm just looking at 3.7 for now.
Yes.
And the same words were used in the 2007 TMLA. The same words were not used in the 2005 TMLA.
I mean, how do you say? I find this really rather difficult. If I'm seeking to interpret an agreement, I'd rather like to look at the agreement. And if I'm told, well, the parties previously entered into other agreements about the same subject matter, I mean, that can, in the case of ambiguity, be relevant. But in this particular case, a lot had changed by the time of this agreement, hadn't it? So we do have to look at how these words fit together in this agreement, primarily. So do you say we need to spend a lot of time with 05 and 07, or do you say that actually it's clear on the face of here?
I say it's clear on the face of here. But even if that's not right, the court is obliged, we say, to look at what went on in 2005 and 2007 to see the regulatory...
If that is not clear.
If it's not clear.
Yes. To see what?
Well, to see the regulatory regime which led to that clause being incorporated and included. And what the court can know from the relevant factual matrix, both in relation to 2005 and 2007 and then 2014, is that there was a particular regulatory context within which this clause initially came to be included and subsequently came to be restated for the purposes of the 2014 agreement. And yes, there had been factual changes of circumstances as between 2007 and 2014, in particular the IPO. I absolutely accept that. But what the parties are agreed on is that the meaning of this clause is the same in 2007 as it is in 2014. So to that end, insofar as the court is looking at factual matrix or purpose, we say the court does need to look at what happened in 2005, 2007, and then in 2014 as
I mean, the fact that the parties agree that the meaning of the 2007 agreement, or this clause, meant the same in 2007 as it does in 2014, does not mean, does it, that we should start with 2007 to find out what it meant then, because that's just your agreement. The proper process of interpretation is to start with 2014 and see what that means. And only in case of uncertainty from the 2014 agreement do we look back and consider the parties' agreement that it meant the same in 2007. I mean, for my part, I don't care what it meant in 2007 because you're not litigating about it.
No. We're not litigating about what happened in 2007. Absolutely, I accept that. But what is perfectly legitimate as an aid to construction or interpretation is the analysis of previous agreements between the parties. Here, you have previous agreements which are then restated as the agreement expressly recognises in 2014. To that end, we say the court is, when construing the agreement by reference to, or interpreting the agreement by reference to the 2014 position, to look to see what happened in 2007. Why, as a matter of regulatory action, that clause came to be included, and the extent to which, as a matter of regulatory approach, a different position was being adopted by the regulator to questions of, in particular, royalties and freedom to manoeuvre.
I mean, you see,
in
I find all
2014.
this, I mean, I get what you're saying, but I find it all quite difficult to say that the intention of the Department of Transport should be relevant to the meaning of this agreement, which is what some of the skeleton arguments seem to tell me. You know, they say the key document in this case is the letter of October 2014 from the Department of Transport, and then we should construe that as a deed. Well, I don't think that that sounds the right approach at all, unless we are in the territory of serious ambiguity. And even then it's the DOT, and it may not be admissible at all.
I certainly don't say that the interpretation of the DOT or the impression that the DOT has of the contract is material relevant. What I say is that the DOT provides a regulatory background to the question of what did the parties intend to do when they concluded the 2014 agreement.
But does it really tell you the answer to the question whether or not Virgin was trying to charge a minimum royalty for the use of its marks, whatever you decided to do by way of usage of their marks? Because plainly the DOT did not want you to have to pay for providing an airline which was not anything to do with Virgin. So you wanted to fly as Alaska, whatever, you should be able to do so without paying that royalty. But it actually doesn't tell you anything about whether there's a minimum royalty, because you have the right, nonetheless, for 25 years to use the Virgin name. And nobody else has the right to use the Virgin name. See clause 3.3. I think. Maybe wrong. But you see the point. I mean, I just don't find that I'm helped by looking at what the DOT thought, because the DOT had a focus on the idea that you should be free to do what you wanted to do without paying them for flying as Alaska. But you're not paying them for flying as Alaska. You're paying them, on their analysis, for the right to use their marks and nobody else being able to use their marks in the USA. That's where it is.
And the issue then for the court is whether, from the party's perspective, the DOT, or they would have understood that the DOT was satisfied or accepted that form of external control.
Well, that's where you get into a lot of things about what the DOT might accept or might not accept. But actually, it's about what the parties agree.
On that I agree with my lord.
Yeah.
It is what did the parties agree? And when one comes to look at what is the factual matrix within which the parties are agreeing, this is a case where there is a regulatory regime and there are regulatory expressions of interest, regulatory expressions of dissatisfaction with various proposals.
Well, there often are, but the reality is, I imagine, that the regulatory regime could not stop United Airlines agreeing to sterilize the Virgin name in America in return for money. Could they? I mean, I'm using another airline just because it's not you, but if you did a deal, if anybody does a deal to say, we buy the rights for 25 years and we have a right not to use them, that's a commercial deal. The regulator may not like it, but probably can't stop it by what it, may have been able to, unless it took out a construction summons as to what this meant.
I think one then is into the realm of speculation, my lord.
Yes, okay.
What one knows here is that there is expressions of concern about control by non-US citizens expressed in 2007 and 2014. That is the genesis for clause 3.7 itself. To that end, we say that factual matrix is relevant. Then in 2014, there has been a change of circumstance. There has been the IPO. The question then is, what does clause 3.7 mean in the context of this restated agreement? Where the parties agree that it has the same meaning, we would submit the court should be slow to say that the meanings were different.
Well, without trying out the whole thing about what the 2007 agreement, I'm a bit suspicious of accepting that the parties say it has the same meaning, because it's a different agreement. It may have
It's an amendment to the earlier agreement.
Yeah.
And what we would say is that the parties before the judge and the judge himself looked at the whole history.
Some would say too much, possibly.
But then the crucial question is, in 2014, what does this clause do? What did the parties understand it to mean? And what would the objective observer think that this clause provided?
What the parties understood it to mean is irrelevant. What an objective observer would read it to mean is what matters.
Yes, and I accept that.
And the real question is what is meant by the words without the payment of royalties.
My lord.
That's the absolute nub of this. And speaking for myself, I'd be really quite interested to know what you said.
So, my lady, what I say, jumping to that point, without the payment of royalties, we say that includes a running royalty based on revenue. We say that would include the minimum royalty, capital M, capital R, included within the agreement. And that, in short, is the answer.
Yeah.
Because royalties in this clause is not a defined term. There is no capitalisation of royalties throughout the agreement. There is no definition of it in the definitions and interpretation section.
So do you accept then that as a matter of natural interpretation one would give it the normal connotation, which means payment in return for the use of a particular mark or an intellectual property right?
It's the grant of rights or the use of the mark, absolutely. It's both things. So it's not just the grant of certain rights, excluding others. It also includes the right to use.
Well, royalties generally involve payment in return for actual use. So if I have copyright in a book and my book is photocopied or used for any particular reason, then I get a royalty on each time it is actively used. Now I accept that in this particular contract we have a slight variant because the contract talks about granting certain rights to use marks and so forth, and that's why you've got a minimum clause, because that minimum clause does not depend on the exercise of the right. And that's, I think, where you fall into some difficulty on the construction of this particular clause, because speaking for myself, I can well see that it says if you don't use the trademarks or the names, you don't have to pay the royalties that would be attached to that use. But it doesn't say anything about the minimum royalties, which is a defined term and which is in exercise of the right to use. And that, I think, is the nub of the argument against you.
Well, going to that then, my lady, if one goes straight to clause 8.1
Yep.
at page 212 of the hard copy, 215 of the PDF, we see clause 8 is about payment of royalties, and clause 8.1 A, B and C identify royalties which are calculated by reference to revenue.
Yes.
And then one sees in the same clause the rider, in each case, subject to the requirement that the user will in each financial year during the term pay at least the annual minimum royalty in accordance with clause 8.6. So we would say that that treats the minimum royalty as part of royalties, no difference from the running royalties provided for in clauses A, B and C. It is a minimum royalty, but it is still being treated as a royalty by the parties to this agreement. So clause, the heading itself suggests it, but that is not definitive, see clause 19.1. But clause 8.1, in my submission, does provide an answer to your ladyship's question. Similarly, if one goes to clause 8.6, so we know to go to clause 8.6 because clause 8.1 tells us that that's where we should go. Clause 8.6 says, for the avoidance of doubt, the user's obligation in respect of payment of royalties due to the licensor in each financial year of the user is to pay the greater of a royalty based on use, which is A, or B, a minimum royalty applicable for the period.
Which is not based on use.
It's not based on use. Absolutely, I accept that.
So it's in return for the right to use rather than the use.
Well, what clause 8.6 does not do is divide up the right to use from the fact of use itself. What the parties have agreed in clause 8.1 and 8.6 is to treat those rights as a package. There may be some use, in which case there is then a percentage of use, but if that use is not sufficient to meet the minimum royalty, then the minimum royalty will kick in. So in those circumstances, the minimum royalty will be reflective of use, because there's insufficient use to mean that the minimum royalty is exceeded. What one can't do is treat a use-based royalty as different from a minimum royalty. Why? For two reasons. First, as a matter of principle, there is no difference. But in any event, on this agreement, it is clear that they are being treated as one and the same thing.
Well, it all depends, doesn't it, on whether what 3.7 is really saying is when you're not using trademarks, you don't pay royalties in relation to those uses. Or whether it's saying if we don't use them at all, we don't pay anything, including the minimum royalty.
Absolutely, that's the question.
And can you help me with this? If you use the brand on just one flight, you have to pay royalty for that flight.
There's an obligation to pay royalty calculated on the basis of 8.1.
Yes.
Depends on the time A, B or C.
Yes.
But that royalty is superseded by the minimum royalty.
Yes. So if you just use, So if you just fly one Virgin flight, that's all, or use Virgin on one part of one flight, you have one badge that says Virgin on one flight, you have to pay the minimum royalty.
Yes. Absolutely. And that's what clause 3.7 says, because it gives the right of election to the licensee to decide whether it will perform the license activities or any other activities using the name or marks. If it does, then it is liable for 8.1 and 8.6, but if it doesn't, then there is no payment of royalties so long as the user doesn't use the names or marks.
Then what you've achieved in doing is completely sterilising this trademark without having to pay anything.
But one hasn't, my lord, because the second part of 3.7 provides the answer.
What, the walkaway clause?
The walkaway. So 3.7 is an agreement in two parts, and Virgin don't look at the second part of this clause at all, because what the second half does is it balances out the interest as between Virgin and Alaska or Virgin America.
Well, to an extent. I mean, the last sentence means that if you don't use the trademark outside the territories, then they can't walk away.
I accept that. Nothing in this provision shall in any way give licence or the right to terminate the licence on the basis of users' non-use of the names outside the territories. But that, to some extent, is directed to 3.6, which is the use of the name for the licence activities. But what that last sentence doesn't do in any event is to mean that the licensor doesn't have full rights to take it back. If there is not use of the names or marks to a material manner within the territories, that's the second sentence of 3.7, then there is the right after 45 days to terminate the licence. And we say that's the deal, that's the bargain that the parties have struck. Otherwise, one is left with the strained construction, and we say it is strained, of suggesting that the word royalties in the first sentence in paragraph 3.7 does not mean minimum royalty for the purposes of clause 8.1 and 8.6.
Well, since minimum royalty is a defined term, and it's defined in the definition section as a separate concept from royalties, what's wrong with that?
Well, my lady, because it is defined, and one looks at the definition at page 204 of the hard copy, or page 207 of the PDF, it's the amount of 7.9 million odd adjusted. So what the minimum royalty by way of definition is, effectively it's an amount.
Yes.
And the minimum royalty is, in the definition, is identifying a figure.
It's a price.
One then has to take that figure or that price into clauses 8.1, 8.6 and see whether that figure, that royalty, is one that is caught by clause 3.7. And we say, it self-evidently does, because it's included within clause 8.1 as being part of the price for the airline rights, and in clause 8.6 it is expressly being treated as part of the payment of royalties to the licensor.
The proviso indicates, does it not, that the parties had in mind that Alaska might, or what became Alaska, might cease to use the names in a material manner. It specifically refers to 20% reduction, as it were, in the use of the brands. But it plainly doesn't envisage, at least expressly, not using the names or the marks at all. And that's not what the clause is directed at on the face of it. And you can see that from clause 3.6. It's plainly anticipated that the names will be used, at least to some extent, thereby engaging the minimum royalty. So what you have to do is say, well, this clause can be read in an extreme way, which is that we have the right to, not only to stop using them, but stop using them altogether and not even pay the minimum royalty.
I would submit that a material manner includes 0 to 20, and what the clause is doing is providing.
You mean 0 to 80, do you?
Yeah,
0 to,
80.
well, yeah, so 0 to 0 use to 20% use. Because there's the 20%
Yes.
derives more than 20. So yes, it's 80. It's 0 to 80, my lord. Absolutely. Yeah. So that is.
This is not. Sorry, I'm sorry. Let me finish.
No.
No, please.
So I say that a material manner includes no use. It includes up to 80% use. In those circumstances, and given the regulatory regime, what one does is, looking at the first sentence of clause 3.7, is say that that is anticipating no payment of royalties in the event of any such non-use of the names or marks.
The problem I see with that is that if the use is 80% or 79% or 78, 76, 75%, all of those cases you pay a minimum royalty.
Absolutely.
But you say that there's one exceptional situation here, which is if you don't use it at all, for some reason at that point, when it goes from 0.00000 recurring 1% down to 0, Virgin loses its 7 million minimum royalty. And at the moment I can't see any commercial sense in you being responsible for a minimum royalty if you even put one little Virgin sticker on the back of a seat on a plane, that you pay 7 million. Sorry, I know it's more than that. It's 7 point something, isn't it? If you put one little Virgin sticker on one plane on one flight, you pay $8 million. If you don't, you pay nothing. And I just don't see the commerciality of that at all.
So the commerciality is this. What the parties knew from 2005 was that they needed to demonstrate that Virgin America was not under the control of a US citizen, of a non-US citizen. So in 2007, clause 3.7 is introduced. And clause 3.7 is directed at that purpose, providing independence to Virgin America to make choices as to how it manages its own business.
But let's accept that as a business basis for this clause. The first part of that clause makes that absolutely clear, that there's nothing else in the license which will prohibit the user from electing not to use the marks. Right? So nothing in the rest of the contract can be read as an inhibition on your client deciding to fly planes anywhere it likes without using the logo Virgin. That's what it means. If you do use the logo, you've got to pay for it. That's what the last few words say, provided that so long as you don't use the names or marks while undertaking such activities, so the quid pro quo is you pay for it. Now that seems to me all to talk about use. You're free to call it what you like and don't pay the use of royalties for that use. But if you do use the logos, then you pay for that use. But none of that talks about the minimum payment. And I think actually ultimately this argument all turns on whether you're right about clause 8.1 and the words minimum royalties are read as part and parcel of royalties generically.
Your Lordship may well be right.
Yeah.
That was certainly the point that the judge found.
Yes.
Effectively, the judge found that a capital M, capital R minimum royalty is not a royalty for the purposes of the first sentence in clause 3.7.
Yeah. And you're saying, well, it's all treated as if it were, because look at clause 8.1, look at clause 8.6. And you say, well, if we're free to use, not to use the trademarks at all, and we can, when we, in order to demonstrate to the regulator that we are completely uninhibited and not under any sort of obligation to Virgin, then it must necessarily follow that we don't have to pay them the money, and the quid pro quo is that they can terminate.
Absolutely. That is, in a nutshell, that is the argument, and that's the point that the court will need to determine.
Can I ask you, if you're right in your construction, why do you accept that minimum royalties are payable if trademarks are used at all? Because surely the effect of that is that royalties are being paid for the use of the brand, for effectively in relation to usage where the brand is not being used.
The answer comes to that question in the concept of election in the second sentence of paragraph 3.7. Because what it is doing is giving the licensee the power to elect to perform license activities or any other activities without the payment of royalties. But the condition for that is that there's no use of the names or marks. If there is use of the names or marks, then clause 8.1 provides that there should be payment of royalties. The question then is, what are those royalties to be? Paragraphs A, B and C do not bite on revenue derived from non-Virgin branded activities, but the rider in clause 8.1 bites. And that is the answer. That is how one balances out the fact of.
Why don't you employ your notwithstanding any other provision in relation to that and say that can't be right, because the effect of that is that you're paying royalties in relation to non-branded licensed activities.
But you're not. Well, you may be paying monies that come from profit made from non-branded activities, but what you're paying is a royalty. The royalty kicks in because the user is using the names or marks while undertaking some activities, to use the language of clause 3.7.
And Virgin would still be able to terminate on that construction?
Yes.
So you're in a bit of a fix then in terms of commerciality of that bargain. So you use the Virgin logo on one flight. That's less than 80% of your turnover. You've got to pay the 8 million because you haven't generated enough income from that to be able to pay royalties from the use of the trademark. And Virgin can elect to terminate the licence on 45 days' notice and pocket the 7 point whatever million it is minimum royalty.
For that year, absolutely. But that is the election that in those circumstances the licensee would have taken. And that is the regulatory concern that comes out of both the 2007 licence and the 2014 licence. It's keeping the independence of Virgin America to be able to decide how it should operate for the purposes of running an airline. If the commercial decision was one flight only using the Virgin brand, then the repercussion of that choice is the payment of the minimum royalty. But if there is no use of the brands at all, then clause 3.7 bites, because the only types of payment that Virgin would be entitled to receive are royalties in those circumstances. And it can't receive royalties, neither in relation to usage or profit, nor in relation to the minimum royalty. And it's important to remember that what the clause is doing is talking about use, not about profit. So there is the possibility of being able to use the names without generating revenue. In those circumstances, one well sees why a minimum royalty is a royalty, not something else, because it is being used to reflect the right that Virgin America has to use for profit, not to use for any profit, or the grant to stop other people from using the brand. But if it uses the brand in any way, then it is subject to clause 8.1 and clause 8.6. So I hope that has answered my lady's question. The other crucial part of clause 3.7 is an argument articulated by Virgin, which focuses on the words while undertaking such activities. And those words receive a lot of focus in Virgin submissions. For example, paragraph 10.5, paragraph 11.1, 11.2, 11.4, 11.5, 16.2 and 22. They don't receive focus in the judge's reasoning. I'll deal with them nonetheless. As we see it, there are three strands to Virgin's argument in relation to those words. First, they say that the words are directed at various kinds of commercial activity and are permissive of the relevant commercial activity. That's Virgin Skeleton paragraph 10.2. We say that's not right. It looks at commercial activity and introduces the concept of commercial activity in circumstances where that is not what the clause says. What is clear and what is meant by license activities or other activities is anything that Virgin America wishes to do, it may do without the payment of royalties, so long as the user doesn't use the names or marks while undertaking whatever it is that Virgin America wishes to do.
Why doesn't it mean what it says?
Well,
which is that it's not paying royalties if it undertakes license activities or any other activities, not using the names. Doesn't pay royalties on that stuff.
Yeah.
And why doesn't it mean that?
So it does mean that.
Right.
But Virgin seek to then make it mean something more. Because what they say is that that is effectively a limiting provision.
Well, aren't you saying it means something more?
No, my lord.
Because you're saying it means without paying of any royalties at all, even those provided in the definition for minimum royalties and in 8.1 for minimum royalties, which are, by the way, paid for the right to use, not the usage. It is the right to use that matters. You are, I think somebody used the word sterilizing, you are keeping the right to use this brand to the exclusion of other people, and you say you don't have to pay for that. I don't see why this clause says that. This clause is for you. What it says is you can do stuff and not pay a running royalty or whatever you call it for however much you fly around the world flying Alaska or some other name. It doesn't say anything about whether you pay for the right to use the Virgin name, which you're keeping in your pocket.
My lord, we would say clause 3.7 is not just a clause directed at benefiting Virgin America.
Right.
It is a two-handed clause. The first half, absolutely, I accept that the first half of the clause does benefit Virgin America.
Yeah.
But the second half means there is no sterilisation.
Well, I mean, that's the point I put to you right at the
Yes.
beginning. I mean, that seems to me critical to your case.
Completely.
But it's a slightly strange way of. It's slightly strange that the only way they can get the money that they bargained for giving you 25 years of the right to use the Virgin name is by terminating the contract.
Well, that won't give them the money.
They
They just
won't give them the
terminate and
money.
they give it to somebody else.
Yes. But that is the bargain. They can terminate and they can seek to license someone else with the Virgin brand.
But one of the things we don't find when we read 5 million pages of pre-contract negotiations, discussions and everything else is that.
No.
No, my lord.
No. So that bargain is never explained anywhere.
No.
No.
And the extent to which that would have been admissible an explanation in any
No,
way.
it wouldn't have been admissible, but then I'm very doubtful whether all the other things that were admitted were admissible. But there we are. I mean, ultimately, it does seem to me to be about what this clause means, because if you read it the way I've just put to you, and my lord and my lady have been putting to you, I think, as well, in different ways, it's not really ambiguous. Because royalty doesn't include minimum royalty, and why should it?
I would say that the objective, reasonable observer would think it's an odd result.
Well, that's
That-
I think...
no,
Yeah.
if I just finish, my lord, I apologise.
Yes, of course.
But it would be an odd result if something that is capital M, capital R, minimum royalty, is not a royalty.
Right, okay. But I think the point I was putting to you is that without the payment of royalties is without the payment of royalties for not using the name.
But, my lord, that is reading into the clause more than the clause currently says, and it is inconsistent, I would submit, with clause 8.1 and 8.6.
Except it's what the words say. It says without the payment of royalties, as long as you don't use the name.
No, well, it's about the payment of royalties for use.
Yeah. Okay.
It's-
I mean,
it's-
I think this is like all
Completely, my lord.
questions of interpretation. Once you get the two sides, you have to decide.
Can I just make the point that the defined term is minimal royalty, but it doesn't actually say that it's a royalty.
No,
It's just a payment of an amount.
It is setting the amount, and then one has to use that amount to populate clause 8.1 and 8.6.
Yes.
If they'd used a different term, such as price or minimum sum,
Minimum sum. Your case is dependent upon reading that defined term, the word royalty, as having some specific significance, but it's just the label that's been put on the minimum amount that will be paid in each year.
My argument is assisted by the fact that it's called a minimum royalty and it's called a royalty. Absolutely, I accept that. But in addition, the objective observer, I would say, would take that into account. And I at the risk of repeating myself, I do submit that the objective, reasonable observer would think it odd that a capital M, capital R concept, which is called a royalty, is not a royalty for the purposes of clause 3.7. So that's the first point. The second point is one of construing clause 8.1 and 8.6 together. Because what clause 8.1 is doing is treating the minimum royalty, which we know is a figure, and it's a figure that is subject to RPI or inflation. That's why the figure is not just included expressly in clause 8.1 in the rider. But the clause is treating both the running royalties based on revenue in A, B and C, along with the flat fee payable in the concluding words of clause 8.1. So it is treating royalties based on revenue. It's not necessarily use. Well, it's not use. It's royalties based on revenue in ABC, because there could be use without revenue, as I've already said. The rider then provides that there shall be a minimum royalty, and it's a figure set out in the definitions, but we know from clause 3.7 that no royalties will be paid in the event that there's no use of the names or marks. So those two factors, what it looks like to the reasonable observer, I mean, it would be an odd result if a minimum royalty is not a royalty, and then the way in which the parties themselves have treated it for 8.1 and 8.6, we say leads to the conclusion that the minimum royalty is a royalty covered by clause 3.7, and on that basis, if there's no use of the names or marks while undertaking licensed activities or any other activities, then there shall be no payment of royalties. That's the answer. That's the answer by reference to clause 3.7, and that's the answer by reference to clause 8.1 and 8.6.
But it could easily have said, couldn't it? And if the rights are not used at all, there should be no obligation to pay the minimum royalty.
Absolutely. It could have said a number of different things.
Yeah.
But generally, the question of contractual interpretation is best answered not by saying what the agreement could have said, how could it have been put differently. That debate ends up often being very arid. And Virgin at some points have said, oh well, it could have said this, and at some points they say, well, you can read it as being X, Y, Z. The question for this court is, does the construction that I have, or the interpretation that I have put forward, reflect what the agreement says? And we say it does. Those are the submissions that I wanted to make in relation to clause 3.7. The fourth area of my submissions was the wider contractual context, and I've dealt with some elements of that already by looking at clauses 8.1 and 8.6. If I can just check whether there's any further points that I need to make in relation to 8.1 and 8.6, I'd be very grateful. I think there's just one further point that I do want to make, which if one takes up 8.1 and 8.6, and one remembers that clause 3.7 is the overriding clause, then one could include in any of these paragraphs, so for example, at the beginning of clause 8.1, subject to clause 3.7, in consideration of the airline rights granted pursuant to this, user agrees to pay licensor. And then in the rider at the end, in each case, subject to the requirement that the user will, in each financial year during the term, subject to clause 3.7, pay at least the annual minimum royalty in accordance with clause 80.6. And given the way in which clause 8.1 is structured, we say that that would be entirely legitimate. Similarly, if one goes to clause 8.6, the avoidance of doubt, the user's obligation in respect of payment of royalties due to the licensor in each financial year of the user is, and then one could add in the words subject to clause 3.7, to pay the greater of the royalty identified in clause 8. Little a, and the royalty identified in little b. There's obviously no need for those words to be included because 3.7 is, as I've said, an overriding or trumping clause. And that is why, ultimately, it is unnecessary to draw a distinction between the payment of royalties for the grant of rights in the names or marks and the payment of royalties for the right to use, or between the grant of rights under 3.1 and the use of the names or marks themselves. Because, and that was a distinction drawn by the judge at paragraph 161 of the judgment, and we say that that is unconvincing. We accept that one part of the royalties identified in clause 8.1 are calculated by reference to revenue, not use, but revenue. And one sees that because the definition of gross sales at internal hard copy bundle, page 203, page 206 of the PDF, looks not at use but at sales, or revenue generated, the total amount received by the user. To that end, it makes no difference that revenue is being used for ABC in clause 8.1 and that a flat fee, an annual minimum sum, is being set out in the rider. They both are royalties referable to the grant of rights under the agreement. Neither is directed at controlling use, save insofar as there is no sufficient use by Virgin America, because if there's not sufficient use to generate sufficient income, then under clause 3.7 there is the right of the licensor to terminate, and that is despite the existence of the annual minimum royalty. So it could be a position where Virgin decided that the annual minimum royalty was not sufficient. Indeed, Virgin might decide that even though the revenue being generated was more than the annual minimum royalty, they might still want to terminate. And they would be entitled to do so if the annual minimum royalty is superseded by the revenue generated, and the revenue generated is insufficient to be 20% of the operating revenue of the licensee. I'll say that again.
That's not right.
The second half of clause 3.7 allows for termination if the revenues are not being used in a material manner, and that includes, but is not limited to, where the licensee derives more than 20% of its operating revenues within the territories without using the name. So suppose one looks at the overall amount that the licensee is generating. If the licensee is generating more than the minimum royalty would generate by way of revenue-based royalty, but is also generating more revenues than those revenues reflecting 20% of its operating revenues, then clause 3.7 would permit Virgin to terminate the agreement. Because the minimum royalty is not sufficient, or is not completely sufficient, to prevent the ability of the licensor to terminate. And that is a reflection of the fact that revenue is being used in this agreement for two purposes. One, licensed activities using the brand, and then the other activities of the licensee. if the licensee is doing so much business that neither the minimum royalty nor the revenues are more than 20% of its operating revenues, then there's the ability on the part of the user to have the license taken away from them.
So,
I mean, I don't think that's right.
I don't think it's right either.
Well, as a
I
matter
mean, I think you're. I mean, it's a rather convoluted proviso, but what it says is, in the event that the user ceases to use the marks in a material manner, it doesn't really matter that bit, but in the event that it does that, which includes but is not limited to where the licensee gets more than 20% of its operating revenues without using the marks. So what it's envisaging is, at the very least, you reach a 20% threshold, getting income from other sources without using the marks, from the other licensed activities without using the marks, then you're at risk. But it actually says you might be at risk even for less than that, because it's not limited to where you get more than 20%, but obviously it is when you get to 20%. So it's actually looking at really almost a hair trigger for Virgin. The Virgin are well protected by this proviso. They can show you get to 20%, then it's obviously covered. They can give 45% notice, and 20% from all sorts of things, because it says operating revenues within the territories, and operating revenues is not defined, I don't think. So I assume it's any kind of operating revenue, not just selling tickets in an airline.
I've explained the position very poorly, but effectively the point that my lord makes is in effect the right one, and the practical example would be this, and this perhaps I hope explains what I was trying to say. Suppose the licensee derives 25% of its revenues from non-Virgin related materials.
Yeah.
Those revenues might be more, the 75% of the revenues may generate more than the minimum royalty, but nonetheless, Virgin would be entitled to terminate. That demonstrates that the minimum royalty is part and parcel of the deal for royalties.
It's got nothing to do with it.
Well,
I mean, the minimum royalty's got absolutely nothing to do with this proviso.
it's part and parcel of it, because suppose one has the opposite position. Suppose one has the position where 25% of the licensee's revenues derive from things other than Virgin materials.
Yeah.
But those activities, the 75%, don't generate more than the minimum royalty. So the minimum royalty is payable. Nonetheless, Virgin has the ability to terminate.
I think the point can be rather turned around against you, can't it? Which is that proviso is anticipating a diminution in royalties on the gross sales basis because you're not using the brand. And you're quite right that in deciding whether to exercise that right to terminate, one of the factors that Virgin would have to take into account is whether it is what it will receive by way of the minimum royalty. And the idea that decision will have to be made in the context that if it dips down to zero, they don't get the minimum royalty, is rather bizarre, isn't it?
Well, it's providing an election to Virgin to decide what it wants to do.
You see, I think the problem is that, and it may be a historical problem, when you entered into this agreement, you were thinking of using this brand to run an airline. And that's what clause 3.3 protects you from them licensing somebody else to use it. And 3.6 is an undertaking that so long as you provide the licensed activities, you'll continue to use the names and use reasonable efforts to promote the conduct of the licensed activities under the names. So that was what it was originally, but then all of a sudden we get introduced clause 3.7, which is not really a royalty clause. What it's saying is, oh well, but of course, if you fly under the name Tesco, you won't have to pay royalties for flying under the name Tesco, right? And then we're then sort of thrown into confusion as to where that will leave us. And the assumption of the clause seems to be that you will be flying under the name Tesco for some, maybe only a little bit, and that's what this clause is allowing you to do. And then Virgin, if you do that even a little bit, can terminate and get their license back. But it's not saying, as far as I understand it, that you don't pay any royalties for the right to use the name Virgin, even if you don't use it. It doesn't actually say that.
It's important to look at my Lord's question at two moments in time.
Yeah,
2007,
yeah,
Virgin America is effectively controlled by Virgin,
yeah,
and it is important to create a degree of independence sufficient to satisfy the regulator.
yeah.
At that stage, I would accept that it was not in the parties' minds to provide for a clause which would, on the event of a complete debrand, protect the debranded entity from any form of revenue sharing, any form of revenue obligation to Virgin. And that is why in 2007, the parties conclude clause 3.7, and at that stage, there is no minimum royalty. By 2014, the position is different, because by then, the likelihood of a debrand had increased, and that's the judge's finding, paragraph 1582. That does make a difference, because at that stage, the parties and Virgin positively contended for the risk of debrand at trial. The parties then have in mind the possibility of a debrand. They leave clause 3.7 as it was originally framed, and we would submit that clause 3.7 does catch exactly the debranding situation because of the way in which the minimum royalty is included within the agreement. It includes a minimum royalty as a royalty in the event that it was not to be treated as a royalty and was a flat fee payable for the entirety of the term, irrespective of the form of use. We say that is something that would need to be spelt out. It's not spelt out in the agreement. It's common ground that it was not spelt out to the DOT. The DOT was shown the marked up version of the TMLA, but no one said to the DOT, and the judge makes no finding that this happened, that come what may, for 25 years, there would be an obligation to pay a minimum royalty even if the debrand occurred.
I don't actually see what that's got to do with the DOT. I mean, the DOT is interested in making sure that you're not under the control of a non-US entity. Paying them $8 million a year for the use of the brand is not going to give them any control over you.
Well, it would give control, my lady, insofar as there is then a need to use the brand at all.
Well, there isn't. You've said we don't need to use the brand, but you still end up paying $8 million for the use of it, or $7 million for the use of it.
I can see the competition regulator being interested.
Yes.
But I can't see the DOT being interested.
The DOT and the competition regulator, to some extent, walk
Hand in
hand in hand.
Do they?
But
But
that's
I mean, I'm supposed to take
No.
judicial notice of the
No.
competition regulator's relationship with the Department of Transport in the United States, am I?
But what? No, my lord. But what your lordship does know is opinions expressed by the DOT in the context of both the 2007 and the 2014 agreement. And I'll come to those in a moment, if I may.
Okay. Yep.
Could I just ask you, just go back to the proviso and its potential relevance to the minimum royalty? You're operating the election, you're deciding the election to terminate, not upon the past, but upon the future. So you're going to have to assess whether or not it's worth maintaining this license, or whether you might get more elsewhere. How do you know what you're going to get? That's assuming that the licensee is starting to decrease its use of the brand, and its usage goes down just below 80%.
Yeah.
Well, when you're looking forward to the next year and the years after, what do you assume? Well, you assume, prima facie, you're going to get the minimum royalty each year. But you say, well, you can't be sure of that, because if usage goes down to zero, you don't even get the minimum royalty.
Yes.
Well, how does a sensible commercial party decide whether to exercise that option?
A sensible commercial party will know that usage is reducing, will know that at some point there is a risk that there will be no use at all. The process of debranding is far from straightforward, and there was evidence before the judge as to the process of debranding. So the decision to debrand is one that is not to be taken lightly.
No, I understand all that, but the question at the end of the day is the commercial one. This gives a right to terminate. How commercially does that work if the licensor doesn't know whether or not they will be entitled to what on the agreement is described as a minimum royalty? Surely, as a matter of commercial common sense, the licensor would be proceeding on the basis that they will at least be entitled to the minimum royalty.
Subject.
Your argument completely undercuts that.
But that is the effect of the first sentence in clause 3.7.
Well, that's just saying you're right because you're right, isn't it?
Well, no, my lord. That is what we say. That is what 3.7 does. The commercial reality behind that is one that debranding is not straightforward. One would expect a licensee and a licensor to have discussions in circumstances where usage is dropping, and then the licensor has to take a decision as to whether or not
We
it
can't
wants.
construe this on the basis they might have discussions.
Well,
So interpret it.
What the court is entitled to do is, in the particular factual scenario that your lordship puts to me, to consider the converse position, i.e. what might happen if that happens. So if the court is going to involve itself in a speculation as to what might be the position in circumstances where there is an ongoing reduction in use, leading to an ongoing reduction in revenue, then the question for any licensor will be, what do we do in respect of that? Do we continue to bank on the minimum royalty as sufficient? Do we say, in circumstances where it may end up being a debranding situation in its entirety, do we go to the market and see whether we can find anyone else who would take on the brand? And can we exercise then our rights under clause 3.7?
Do you accept the point that, just looking at it in very broad terms, as a licensor of intellectual property rights, you may well be proceeding on the basis that, if nothing else, what you're going to get is what is stipulated in the contract as the minimum royalty?
Absent the first sentence in clause 3.7, yes, that's what a licensor will expect, subject to other rights of termination that exist within the agreement. So a licensor who is carrying an IP right that becomes less valuable because the IP right is in some way subject to derogatory treatment, similarly has the risk and the commercial risk that that will occur, has the risk and the commercial risk that the licensee will terminate in those circumstances.
I think we're running up a bit against time.
Absolutely.
Here. I think you should probably go on with the factual matrix points you want to make if Mr. Ho's going to be allowed to develop his 2 points.
Absolutely. Can I just make a few points on clause 3.6, because that
Yeah.
was something that the court was particularly concerned about. In relation to clause 3.6, our short answer is that the beginning words are the answer to the points, because the clause expressly anticipates that clause 3.7 will be the overriding clause. That's the first point. The second point is that we say that there is no surplusage, and that properly construed, clause 3.6 is an undertaking that for so long as the licensee does not exercise the right of election in clause 3.7, it shall do so using the names and the marks, and shall use all reasonable efforts to promote its conduct of the licence activities under the name. If the licensee uses the names at all, then clause 3.6 requires that use to be more than de minimis. So it provides protection for the licensor in the event that the licensee makes a minimal use. And of course, clause 3.7 provides for a remedy in the event that whatever use there is doesn't generate sufficient revenue as compared to the licensee's other activities. But what clause 3.6 does not do is confer a positive obligation on Virgin America to use the names. And so that's why we say there is no surplusage, and for that reason, clause 3.6 doesn't provide the answer that Virgin wants. The third point is that even if there is any surplusage, that doesn't take Virgin anywhere, and we've cited the authorities on surplusage, and given the time I'm not going to turn them up, but it's Lewison 7.24 and 7.25 and 7.26, which are in Authorities Bundle tab 6, page 187 of the hard copy bundle. It's a concern that is, or its weight as a concept is much reduced. And here, given the regulatory framework for the insertion of clause 3.7, we would submit that there is no basis for seeing clause 3.6 as conferring on Virgin America in circumstances where it has elected to perform the licence activities or any activities without the payment of royalties in breach of that clause. My fifth area of submission was Virgin scenarios, and I will leave that, given the time, for my reply. We say Virgin scenarios do not provide the answer that the respondent contends for. And in short, and by way of nutshell, perhaps I'd just say this. The judge didn't look at these scenarios in his ratio. He recited them, but did not use them for the purposes of his ultimate analysis. We say that Virgin's reliance, in particular on scenarios 3 and 4, no commercial activities and no Virgin activities, do not provide any particular answer. But I think I will leave those to see how Mr. Toledano develops them in his submissions. The sixth area of my submissions is the purpose of clause 3.7 and the factual matrix. And that, at the risk of trespassing on territory that the Master of the Rolls has indicated is not important, we do submit that the starting point is the 2005 agreement, it does not contain clause 3.7 and contains an unmodified version of clause 3.6. That clause was not acceptable to the DOT. It needed to be recast, and the parties knew that whatever recasting was done needed to meet the requirements of the DOT.
How do you deal with clause 19.3 of the licence?
19.3 we would say it is a clause that the court obviously and the parties need to bear in mind. We say it doesn't prevent looking at the factual matrix. It is a clause which says that the agreement is representing the entire understanding, supersedes all previous representations, understanding, licenses or agreements. But the clause in the 2014 agreement itself is saying that it is restating and amending the existing license. So those licenses are part of the factual matrix for the purposes of understanding what this agreement is about. So clause 3.7 is a modified version of clause 3.6. And from the perspective of the licensee, at a principled level, the purpose of the first sentence was to maintain the licensee's independence and ability to operate outside the franchise. And in terms of practicality, that meant that the licensee was entitled to elect to operate without the payment of royalties, so long as it did not use the names or marks. The extent of that operation would be a matter for the licensee to determine. From the perspective of the licensor, at a principled level, the purpose of the second sentence was to protect the licensor from underuse of the names and brands. That was the quid pro quo for the amendment to clause 3.6 and the introduction of the rights in the first sentence of clause 3.7. And what, as a matter of practicality, it did was to provide the licensor with the ability to prompt the licensee into action by serving a notice. In the event that the notice was not sufficiently complied with, then there's a right to terminate. Before the judge, there was a substantial amount of evidence detailing how the parties had dealt with the DOT in 2007 and then how they dealt with the parties in 2014. And we have set out the relevant passages in our skeleton argument, and the judgment itself sets out a number of important matters. What I do want to show the court, if I may, is in some additional matters that are not included in the judge's judgment. And if one could take up, please, first the supplementary bundle. And have at the same time open the judge's judgment. One picks it up at page 86 of the core bundle, in hard copy, page 89 in the PDF. Paragraph 6 is the beginning of the certification process. Paragraph 7.
Sorry, I'm asking about the paragraph in the judgment that you were getting.
Yes, sorry, paragraph 6.
Paragraph 6, yes, thank you.
Which introduces the DOT. Paragraph 7 deals with the application for certification. And then one sees at paragraphs 8 and following a number of matters. What we say is that these passages, taken as the judge has set out, demonstrate the purpose for which I have already contended. There are additional matters that one could, given time, show the court. For example, in paragraph 10, at page 88 of the hard copy, page 91 of the PDF, we see the judge looking at Virgin America's response to the DOT, and there is one important part that is omitted, and that in the supplementary bundle is at tab 3, page 64. That's 64 of the hard copy, 67 of the PDF. And it's under the heading B, notwithstanding the flexibility that the licence already provides Virgin America to operate within the territories using the Virgin name or outside the territories without using the Virgin name, Virgin America is willing, as a condition of gaining the economic authority, to amend its licence to make clear that Virgin America is free to operate completely free of the Virgin brand and to freely code-share with any carrier domestically or internationally, anywhere, and with any carrier. And the judge sets out the footnote to that passage, which is footnote 159 in his judgment, paragraph 10, little 5. But we say that is important as informing the basis on which the parties, Virgin America and Virgin working together, were seeking to persuade the DOT of particular matters. Then back in
well, it doesn't help you, because the understanding there was that you would continue to pay royalties in full as and when due.
At that stage on revenue, not in relation to the minimum royalty.
Well, it doesn't say.
No. But at that stage, that is the position, because this is in 2007. This is not part of the 2014 transaction. If one then goes on to the final order made by the DOT, which is set out by the judge in paragraph 18. So the judge's judgment, paragraph 18, page 94 of the hard copy, page 97 of the PDF. The final order is in the supplementary bundle, paragraph, page 200. Sorry, page 191. And there the judge sets out some material in paragraph 18, but it's important to bear in mind a little bit more that the judge doesn't cite, and that's at page 194 of the hard copy, page 197 of the PDF. And what one sees in the second paragraph on page 194 is the passage cited by the judge that starts 6 lines up from the bottom of that paragraph. So it's the paragraph beginning AFA CWA. We see the passage cited by the judge: payment of royalties on revenues not derived from use of the brand name would undermine the applicant's independence. Therefore, we propose to condition the applicant's certificate on an amendment to the licence that allows such activities to occur without royalty obligation. Now, we say that assists us, but look also at the previous sentence. We saw no reason why the applicant's operations outside of the licence should be subject to a royalty obligation to the Virgin Group. And then the final sentence: we continue to believe that our condition, along with the other changes that Virgin America had agreed to make to the trademark licensing agreement, eliminates any concern about the trademark agreement as an element of control in this case. So although my lady puts to me the question that simply paying money can't be an element of control, we would submit, admittedly not in 2014, but one sees in 2007 the DOT expressing concern that the trademark licensing agreement could be an element of control in this case?
Well, on the basis that you were obliged to pay royalties for the use of the Virgin brand on revenues that were not derived from the use of the Virgin brand.
As at 2007, I accept
Yeah.
that.
Well, that's their concern.
Then it's in that context one goes to the position in 2014, which is in the supplementary bundle, tab 24, page 314 of the hard copy, page 317 of the PDF. This is dealt with by the judge in paragraph 37 of his judgment. And we say that paragraph provides an important background to the 2014 TMLA. One sees the DOT saying, specifically you note, this is in the second sentence, that the term of the TMLA would be extended for 25 years and the TMLA would no longer be subject to minimum revenue thresholds. In addition, commencing in the first quarter of 2016, royalties would increase from, and then sets out the various figures. The amended TMLA would also require Virgin America to pay the Virgin Group a minimum royalty payment if Virgin America's royalty payment from licensing fees would otherwise be less than that minimum payment. The Virgin Group would also be provided with the right to appoint one representative to the board. You also note that the amended TMLA will continue to permit Virgin America to operate independent of the Virgin names and marks without the obligation to pay royalties. And we say that that sentence similarly provides an important background to the approach that should be adopted. And we say the judge erred in his approach to that letter and in relation to that position, and we set out that position in our skeleton argument before your lordships and my lady. So we say, by reference to the purpose and factual matrix, that what one gets is a concern for independence, concern for independent on the part of Virgin America to be able to operate without payment of royalties in the event of no use of the brand. Seventh, business common sense and the reasonableness of the result. I've made a number of submissions in relation to that position already. We make those submissions in our skeleton argument paragraphs 60 to 66. The first point that we make, and it's a point that I alluded to when referring to the Bank of Nova Scotia, is that we say the judge's approach to business common sense was wrong. He did not, we submit, in the judgment paragraph 1613, look sufficiently at the overall purpose in the round. He focused only on the D brand from Virgin's perspective, not from the perspective of Virgin America. And the risk of a D brand cuts both ways. Given the power conferred on Virgin by the second half of clause 3.7 to terminate the licence, in the event of underutilisation of the brand, then the judge was wrong to view the possibility of D brand only from the perspective of Virgin. And then we make 5 other points in writing, which I, given the time, don't seek to elaborate any further on, but I do present to the court.
Can I ask you, do you accept that when the court looks at business common sense, commercial purpose, one very fundamental approach is that the court assumes that nobody is going to get something for nothing and nobody is going to give something for nothing. That's exactly what you're intending for here, is that you have these rights and Virgin has provided them to you, but you pay absolutely nothing.
I don't accept that that is the situation because Virgin has the ability to terminate the
No,
license.
sorry, forgive me, that can't be right. There's a contract between you, pursuant to which you have got the rights. Virgin has granted them to you, but you say you don't have to pay anything for them. The fact they have a right to terminate is another matter. At the moment, you're contending for a contract in which you don't have to pay anything for the rights.
We have the right of election not to pay royalties in the event that we don't use the brand names. To that extent...
So do you agree? You have the rights, but you say you don't have to pay anything.
I mean, yes, I have the... No, I do accept that.
That's your whole case here, isn't it?
Yes, I accept that we have the rights, which can be taken back by Virgin at any moment, because we are not using the rights.
Yes.
And that is exactly what the contract...
But contracts are generally meant to give parties value. There's consideration. And the answer to it saying, well, this contract is, you're not going to get any of the consideration you bargained for, because any consideration for this, so therefore you can take them back and try and sell them elsewhere. That's not the way we normally approach contracts. We expect the parties have done a bargain in which one person gives something in consideration for the other person giving something.
And what Virgin America did was give consideration for the contract when they first entered into it. They continue to pay royalties, whether on revenue or on the minimum royalty, doesn't matter for present purposes. Then there comes a time where a party wishes to exercise rights that are conferred on it by the agreement.
Well, 2004, we're looking at 2014 now, are we not?
Yes.
It's a fresh start.
So there is the possibility then of debrand. The parties know that there might be a debrand.
Yes.
The parties agree that clause 3.7 will still be in the agreement. The parties know that a minimum royalty is being included as part of, we would say, the royalties as identified within the agreement. For a period of time, Virgin America continues to pay monies under the agreement. There comes a moment where Virgin America wishes to exercise the right of election contained within the agreement. And the quid pro quo for that is that then its rights are in jeopardy. So, yes, it has the right to stop other people for the time being from using the brand. Would it want to in circumstances where it doesn't use the brand? The answer must be unlikely. But in any event, if there was any attempt by Virgin America to do that, one would expect Virgin to exercise the rights that it has, consequential on the election that Virgin America has undertaken. And that, we would submit, is a wholly reasonable result. To put it in the context of you've got rights and you're not paying at all for them, we would submit is not the right analysis. Because in 2014, there is a balanced structure that exists. The position the court is now confronted with is one party who seeks, we say, to exercise the right of election that is contained within the agreement, and the other party doesn't accept that that power of election exists. And it, the other party, won't exercise the rights that are conferred on by the contract.
That's conclusory, isn't it? You've undoubtedly exercised your right to elect not to use the brand.
Yes.
The only question is whether or not you still have to pay a minimum royalty. That's it.
And whether Virgin wants to exercise, for the purposes of this court, absolutely. But more generally, from a commercial perspective, Virgin has the ability to decide whether or not it wants to bring the rights back.
But again, that is the question: is does it have to decide that election with or without the prospect that it will get the minimum royalty if it doesn't exercise the election? So again, it doesn't help us in not answering that question. The question at the end of the day is: in 2014, was it anticipated that if you debranded, they would get nothing, or was it anticipated if you debranded, they would get the minimum royalty? And that's it.
And the answer is, there is no evidence that assists on that issue. The question then for the court is to look at the agreement itself and reach a conclusion. Ultimately, it's the words, and I've developed the words, I think, as much as I can. I'm very conscious of the time. Those are the submissions that I wish to make on ground 1. I know that Mr Ho has limited submissions to make on grounds 2 and 3 in any event.
Thank you. Mr. Ho.
Thank you, my lord. So I'm going to develop briefly round 2 and round 3. Just to recap, round 2 concerns whether the minimum royalty should be prorated, where use of the names and marks stops partway through a financial year. And round 3 concerns whether there is a breach of clause 3.6 if Alaska ceases all use of the names and marks. And in our submission, the answers to rounds 2 and 3 flow inevitably from the answer to round 1. So if we have lost on round 1, then we accept rounds 2 and 3 don't arise. Equally, if we have succeeded on round 1, then the court will have found, first, that clause 3.7 applies notwithstanding any other clauses in the current TMLA, and second, that clause 3.7 has the effect that no royalties are payable, including the minimum royalty, so long as Alaska makes no use of the names or marks. And those two findings, we say, must be the starting point when considering rounds 2 and 3, and we say are determinative of them. Round 2 is addressed in our skeleton at paragraph 68 onwards. The factual background to this issue briefly is that Alaska stopped all use of the names and marks by the 30th of May 2019. That was partway through a financial year. The parties disagree whether on the current TMLA's proper interpretation, Alaska has to pay the full minimum royalty for that financial year, as Virgin contends, or whether, as we say, Alaska only has to pay a prorated proportion of the minimum royalty, reflecting that period of the financial year in which it used the name and marks. The definition of the minimum royalty, we have looked at that. That's at core bundle, tab 12, page 204. In the PDF, it's page 207. We've seen that that's a sum for $7.9 million odd, and it's in respect of each financial year. So it's an annual minimum royalty amount. We say, when considering issue 2, the starting point should be the proper interpretation of clause 3.7. We say that issue 2 only arises where the court has accepted that clause 3.7 trumps all other provisions, and that the basic touchstone of clause 3.7 is that no royalties, including the minimum royalty, are payable so long as no use is made of the names or marks. If that is the starting point, then Alaska cannot be obliged to pay in full an annual minimum royalty when it only used the names or marks for part of a year. Were it otherwise, then Alaska would be paying a sum premised on the use of the names or marks for an entire financial year, when in fact it didn't do that. It didn't use the names or marks for all of that period. And that is not, we say, a result which clause 3.7 permits. We've also developed in the skeleton at paragraph 69, two further points which support that. One is by reference to the minimum royalty definition itself, referring to prorating, and we say our interpretation is consistent with that. And one is by reference to business common sense. I don't need to develop that further in light of the time. That then just leaves issue 3. That's addressed in our skeleton at paragraph 71 to 73. Virgin contends that a total cessation of the use of the names or marks is a breach of clause 3.6, entitling them to damages in amount equivalent to the minimum royalty for each year of non-use. We say that if we have succeeded on issue 1, so that Virgin's arguments based on clause 3.6 have been rejected, and the court has instead accepted Alaska's submissions on that clause and the effect of clause 3.7, the inevitable conclusion is that there will be no breach of clause 3.6 if no use is made of the names or marks. In short, clause 3.6 is expressly subject to clause 3.7. If clause 3.7 entitles Alaska to operate free of the names or marks, then clause 3.6, which is subordinate to it, cannot, on its proper interpretation, impose a conflicting and contrary obligation to make some use of the names or marks. We don't understand Virgin to suggest otherwise if their arguments based on clause 3.6, which they deploy in support of issue 1, have failed. But insofar as they do, we'll address that further in reply. And those were my submissions on grounds 2 and 3 unless I can assist your lordship and your lady further.
Thank you very much. Very succinct, Mr. Host.
Forgive me, can I just ask,
Yes.
when you're referring to grounds 2 and 3,
Yes.
these are grounds 2 and 3 at page 14 of the bundle.
Yes.
So those are those the same as you've been referring to issues to?
Those are, I'm sorry, my lord, yes. I've used round and issue interchange.
Yes, I just wanted to
I'm
clarify.
sorry.
Yes, okay, thank you very much.
Good. Mr. Toledano.
My lords and my lady, we submit that the judge was right about the meaning of the first half of clause 3.7. That clause permits non-Virgin branded activity and exempts it from the payment of royalties. The clause does not mean that if all Virgin branded activities ceases, then no payment of any kind can be due. It doesn't refer to Virgin branded activity at all or to its cessation. It only concerns non-Virgin branded activity. Now, since the minimum royalty is a payment due in respect of the right to use the Virgin brand and is not a payment due in respect of non-Virgin branded activity, it necessarily falls, we submit, outside of clause 3.7 in all situations. And we also submit that Alaska's construction is a peculiar one. Alaska accepts, as you've heard this morning, that the minimum royalty is not caught by clause 3.7, where there is some use, however small, of the Virgin brand. And that was the example my Lord Justice Phillips put to my learned friend about one plane or one sticker and so on. But Alaska says that as soon as the use of the brand falls to 0, clause 3.7 immediately operates so as to prevent recovery of the minimum royalty. Now that is, we submit, peculiar, because it means that, according to Alaska, the bite of the clause changes at a particular moment in time, the shift from a small amount of use of the brand to no use at all. And as you know from our skeleton argument, we say that the words of the contract, the factual matrix and the commercial considerations all strongly support our interpretation and the judge's conclusion. And I'm going to deal with each of those three aspects in turn, if I may, starting with the words of the contract. I'm going to start with the royalties briefly as described in clause 8 first.
I think you're, Mr. Toledano, approaching this as if it were a complete rehearing of the interpretation question. And I would be helped by knowing what the judge's reasons were for finding in your favour. Mr. Weisselberg has not really gone to it, except to say that in paragraph 150 and following, he doesn't say the same things as you're saying. Two questions. Why haven't you got a respondent's notice? And is he, well, is he in the wrong order? Is he right? And why haven't, if not, if he is, why haven't you got a respondent's notice?
Well, I don't need a respondent's notice, my lord,
Right.
in answer to that point, because I'm not contending for something different to what the judge concluded.
You might be contending for quite substantially different reasoning.
In essence, the judge's reason was that the minimum royalty did not fall within the small r royalties as that word was used in clause 3.7. That was the essence of his conclusion. It's expressed shortly, but that was his conclusion. And in essence, that is
Just
our
where is
analysis
it
as well.
expressed that? Just help me, because I find his actual reasoning on issue 1 quite abbreviated. Seems to be. I know in this court we sometimes find we hardly ever look at the judgment below, but I find it quite useful sometimes.
Well, it's really 161, my lord, page 138 of the hard copy, and he says in 161.1 that he thinks the words are clear. He says the minimum royalty is a defined term. He explains what it is, a set sum payable for every year of the contractual term, and he explains what that is and how it works. And then you'll see in subparagraph 2, he says he doesn't think that the fact that the minimum is expressed as a minimum royalty means it must be derived from royalties in fact earned, and so on. And then he says it is a flat fee payable for the right to use the Virgin brand, whether or not that right is taken
That's
up.
the key.
And that's the key, exactly, my lady. Your lady is right.
I know that. I mean, I know what he's saying.
Yes,
But I don't find much analysis of what 3.7 means.
my lord, you're right in the sense that the way he has constructed the judgment is to set out extensively what our submissions were and then what Alaska's
But
submissions
has he said anywhere that your submissions are absolutely right?
At the end of 1612, the bit I was just looking at, he
Oh,
says,
I
in
accept-
that regard, I
In that
accept.
regard.
Yes,
But
but
that's-
that, as I say, that was about what does 3.7 mean, and in particular, what does the word royalties catch or not catch in that clause. Hence why I say, in that regard, he was accepting, and your lordship will of course appreciate that he has set out extensively what our submissions were, and that's what he's accepting in that paragraph.
I mean, I'm not being difficult, Mr. Toledano, but I looked in vain for any reference to 3.7 in his reasoning, didn't I?
Well, no.
Seemed to be the clause he was
Your lordship finds it here in paragraph 161. That is what he's doing. He is construing, he is interpreting, to use your lordship's favoured word, he's interpreting clause 3.7 here in this subparagraph.
Well, he says he's interpreting clause 8. Starting point is the words of clause 8. Then he talks about the minimum royalty, and then he says what the minimum royalty is and is not. And then he says, goes back to factual matrix.
Your lordship is right, and I'm not suggesting that you will find a detailed exposition here. But what I think is clear from this paragraph is that he is saying that by virtue of what the minimum royalty is, it is not something that is caught by clause 3.7.
I get all that, and I understand that. But I'm just really asking. It's a slightly technical question. Does he at any stage endorse your argument? So, for example, the bit about your 4 scenarios, I know he sets them out in his, this is what Virgin say, but it's a bit strange if he then doesn't say, I agree with any of that.
Your lordship is right.
Did he say
he doesn't, he sets them out, and we extensively refer to them in closing, but your lordship is right, you won't find in the judgment him saying, I was assisted by this scenario or that scenario, and here are my conclusions about them. And
you really say you don't, I mean, I'm not, again, you really submit, you don't need a respondent's notice. I mean, it's common for a counsel in opening a case like this to say there's no respondent's notice. But Mr. Weisselberg, to be fair to him, has not really majored on it, but it would perhaps have been appropriate, wouldn't it, to signal that you were going to repeat everything in what he'd set out, paragraphs, whatever it is.
Perhaps I accept, of course I accept that, you're just putting it to me, I accept that, perhaps we could have done that, that would have made the position clear. We obviously did make the position
You say
clear
nobody's confused.
in our skeleton.
Yeah.
I think what we took this to mean, in particular the words, I accept Virgin's submissions, and the rest of what he says, the judge said about factual matrix and the commercial considerations and so on, that in essence he was accepting our case. There was nothing, and there was nothing beyond the case we put below that we wanted to put to the Court of Appeal. But I accept your lordship's point. We could have made it clear that we were relying on all of our arguments.
It is a bit exiguous, to say the least.
The judgment.
Yes, this part of the judgment. The rest of it is not everything but exiguous.
I don't think I would get far trying to persuade your lordship out of the view that you
All right,
put to me.
jolly good. Anyway, I just wanted to get that off my chest, sorry.
My lord, can I mention first something about clause 8, and then I'll go, of course, straight away to clause 3.7. Clause 8, obviously we're in the core bundle at tab 12 at page 213. The critical point for your lordships and my lady to take from clause 8.1 is, which you've already, I'm sure, picked up, is that the quarterly payments are a percentage of gross sales, and gross sales are defined on page 203 in the hard copy anyway, as all revenue from the licensed activities. Now that means regardless of whether the Virgin brand has been used or not. So, absent clause 3.7, the effect of the Clause 8 machinery would be that the quarterly royalties would be paid on all gross sales, even if some of those derived from non-Virgin branded activity. Undoubtedly, therefore, 3.7 has an important role to play in permitting non-Virgin branded activity and then also carving it out from the quarterly royalties based on gross sales. And I'll come back to that. The next point I want to emphasise are the words after subparagraph C, the requirement that in each financial year during the term, the user must pay at least the minimum royalty in accordance with 8.6. Now, there's no hint here that this might come to an end at some point during the term at the option of Alaska in the way that Alaska suggests. Now,
I mean, I noticed the point you're making as well. And I thought, again, to use my second favourite word, exiguous, it's quite an exiguous way of dealing with the dramatic scenario of 3.7, not to make any mention of it in 8, that there are these two types of gross sales. There are those derived from the brand and those not derived from the brand, but to leave the first sentence of 3.7 to do all the work here. I mean, you say that helps you.
Well, it does help me because that is the work it was plainly designed to do in 2007 and still the work that it was doing in 2014. You need the first few lines of 3.7 to take out of the gross sales any that are derived from the non-Virgin branded activities, because otherwise they would come within the gross sales and you'd be paying royalties quarterly even on gross sales from non-Virgin branded activity. Yeah. Now, the point I'm making here, though, is that this says very clearly under C that it applies in each financial year during the term. And of course, I accept that 3.7 applies notwithstanding any other provision, but it is, in my respectful submission, still significant that the language here indicates that it applies for every year during the term. Then if we look over the page, you've seen, of course, clause 8.5, where you have the quarterly royalty statements and the quarterly payments, and then you have an annual reconciliation, and that's the way it works. And in 8.5.2, there's a second reference to each financial year, and then you have 8.6, which again refers to each financial year, and the obligation to pay the greater of the quarterly royalties and the minimum royalty, which as you know, can lead to the payment of a top-up if the quarterly payments are less than the minimum royalty amount. Now, can I just draw your attention, you've seen this already, to the definition of minimum royalty at page 204. It starts with a reference again to each financial year, and then as you've seen, it's a flat amount of just under $8 million, with a pro rata amount in case of a partial fiscal year, and also subject to inflationary adjustment. Now, as you'll have seen from paragraph 14.2 of our skeleton, and I don't think this is contentious, the amount of the annual minimum was derived by taking 80% of Virgin America's 2013 revenues and multiplying that by 0.7%, which is the percentage on gross sales. And that works out as a tiny fraction of Virgin America's then turnover. It's actually 0.56% of that turnover, in other words, about half of 1% of the then turnover. My learned friend is therefore obviously wrong to characterise the minimum royalty provision as a, quote, heavy financial penalty, which is something he said in his skeleton. It's not a penalty at all, and it's not heavy in context either.
No, I mean, minimum royalty serves a particular commercial purpose, which is to give you revenue for the use of your brand in circumstances where the income from the use of your brand falls short of that sum. So you're guaranteed a certain amount of revenue each year in return for giving the right to the other party to use the brand.
Or indeed for the non-use.
Or for the non-user. But it's the right. This is basic intellectual property.
My lady,
That's how it works.
Indeed, I entirely agree with that.
What you're doing, as I understand it, and is you're trying to show us how these clauses can be fitted together, rather than Alaska's approach of saying, well, they're in conflict, and clause 3.7 prevails.
My lord, yes, and that's obviously important because, in my submission, that's what this court should be doing. It should be doing everything it can to harmonise and bring all of the clauses of the contract together. All of the cases, as you know, of course, on contractual construction say that you have to look at the particular clause in the context of the whole contract, work out how it works with the other clauses in the contract, and that's obviously fundamental.
Well, of course, you don't even get to the opening part of clause 3.7 if it doesn't conflict.
Well, that's absolutely right. The trumping point only goes so far. If the minimum royalty and 3.7 pass, as we've said in our skeleton, like ships in the night, then it doesn't matter that 3.7 begins, notwithstanding any other provision. It bites on what it bites on. If it doesn't bite on the minimum royalty, then the fact that you've got those words at the beginning doesn't help Alaska. The other definitions, I think you were taken to these, but just very briefly on page 203, midway down, is the definition of airline royalties, which, as you saw, are payable in consideration for the grant of the airline rights. And just above that, you can see what the airline rights are. We don't have to look at clause 3, but essentially they're the right to use the Virgin marks and names in connection with carrying on the licensed activities. And at the top of the next page, top of 204, you can see what the licensed activities are. And as you know, in particular, they concerned the operation of a domestic US airline. So before we get to clause 3.7, which I'm coming to right away, what we have is a quarterly royalty based on all gross sales, whether they are derived from using the Virgin brand or not derived from using the Virgin brand, and a minimum royalty, which is the minimum amount payable in each year of the term in consideration for the grant of the rights. That's what we have. Then we go to 3.7 at page 208. And I won't say anything about clause 3.6 for now, but I'm going to come back to it. I've already dealt with the opening words, notwithstanding any other provision. I don't think I need to say any more about that. Now, as we said in our skeleton, the first half of 3.7 contains what is in effect a permission and an exemption. It contains a permission to elect to carry out certain activities in a particular way and an exemption from the payment of royalties. And our case, as you know, is that the exemption relates to those same activities. That is, the ones for which Alaska uses the permission it has been granted. And it is, we submit, clear that the draftsman was seeking to define a set of activities which Alaska was entitled to elect to perform and to pay no royalties on. That set of activities was defined as those undertaken by Alaska without using the Virgin name or marks.
If that's the case, why doesn't this clause then go on to redefine gross sales and make a division between gross sales derived from the brand and gross sales not derived from the brand? I mean, it's a fairly short-handed way of doing what you say.
Well, your Lordship is obviously right that they could have done it some other way. With respect, this is, in my submission, a perfectly good way of doing it.
Well, I mean,
it's essentially saying...
Isn't there ambiguity in it, using the word without the payment of royalties, without saying, without the payment of, well, without actually defining what happens in the case of partial usage and what happens in the case of no usage?
But the answer to that, this is the point I'm on, the answer to that is to see clearly that the focus of the clause is on a particular set of activities. Once you keep that in mind, and that those are the activities that you're entitled to perform, you have the freedom to perform, and those are the ones that you don't have to pay royalties on, the rest falls into place, because plainly if you don't have to pay royalties on the non-Virgin branded ones, then any revenue from those must be taken out of the gross sales when you come to clause 8. And so it does work once one focuses on the fact that this is about activities. And the reason I say that it's very clear that that is what this is about is that you have the reference to activities at the end of line 2 in the definition of licensed activities. You also have the reference to activities at the start of line 3 as regards other activities. And then importantly, the draftsman returns to, quote, such activities at the end of line 6. So there's one set of activities which are the non-Virgin branded ones, and Alaska is both allowed to elect to perform them and not to pay royalties on them. Now let's imagine for a moment that the words at the end of line 6 had been omitted, so that the clause had said, without the payment of royalties, so long as the user does not use the names or marks, full stop. Now that would obviously change the meaning of the clause, because it could then be said to be all or nothing. In other words, targeted, as my learned friend would have it, at a complete cessation of use scenario. But that's not what the clause says or what it was intended to mean, and those final words at the end of line 6 are important. Now, Alaska accepts that the clause was intended to cover scenarios other than a total cessation of use, such as where there is a mixture of non-use and use. And as the court knows, we placed below a good deal of reliance on the 4 scenarios because we say testing the way the contract works against different facts is an important part of the process of contractual interpretation. And tellingly, we submit, in the mixed-use scenario, which we described as scenario 2 in our skeleton, some activities are Virgin branded, some are not Virgin branded. Alaska accepts the essence of our analysis. They accept that what 3.7 does in that mixed-use scenario is to permit it to carry out the non-Virgin branded activities and to exempt it from paying royalties on those same activities. In practical terms, that means that the gross sales derived from the non-Virgin branded activities are carved out and are not included in those used to calculate the quarterly royalties.
And that is what that, Mr Toledano, is the figure that you would compare against the minimum royalty to work out whether the minimum royalty trumps that or whether you get something on top.
Precisely so. Precisely so. That's exactly right, my lady. And of course, Alaska also accepts in this mixed-use scenario that 3.7 has no application whatever in relation to the minimum royalty. My friend confirmed that again this morning in answer to questions from the court. The minimum royalty, even on his case, remains payable and is not caught by 3.7. And as a matter of fact, that was the position during 2018 and the first few months of 2019, after Alaska had bought Virgin America at the end of 2016, but before it had completed its D brand. During that period, the quarterly payments ought not to have included any gross sales from the non-branded activities, but Alaska was nonetheless obliged to pay the minimum royalty.
So what happened, Mr. Toledano? I've been a bit sort of bemused by this. We don't seem to get any even scene-setting, factual analysis. I mean, did they flew as Alaska Airlines, is it? They flew as Virgin America for the period up until 20...
So Alaska acquired Virgin America at the end of 2016.
Yes.
During 2017, 2018, in the first few months of 2019, they commenced and then carried on a process of debrand,
so
which took some time.
They obliterated Virgin from the tails of their aircraft.
Exactly, they had to repaint. They also had to obviously change all of their stationery and their website and everything else.
I spent 3 years of my life doing a case about Iraqi Airways and Kuwait Airways, where they changed the colour of the airlines many, many years ago, Mr. Toledano. So I'm very familiar with doing all that. But so this is what happened here.
That's exactly what happened. And during that period, which was nearly 2.5 years, there was some operations that were going on still under the Virgin brand, but some that were not. Now,
right, so they did fly some flights with a code share, with a Virgin code share.
So far
until 2019.
So far as I'm aware, they had to have done, because you can't repaint your whole fleet of aircraft overnight.
No, absolutely you can't.
So
and also presumably Virgin colours are quite prominent inside aircraft.
Indeed,
so there had to be refits and all that.
Exactly so. And of course,
how big's the fleet?
I'd have to...
I mean, just in sort of rough terms.
I'd have to be reminded. Forgive me. At trial, I would have known the answer straight away, and now I don't know the answer.
2 o'clock. I'm just interested in this because I'm trying to get a picture of what was actually going on in the real world.
Of course.
But when they entered into the 2014 agreement, there was a possibility of a rebrand, but was there any evidence about what was in the, whether they'd said, oh, we're going to fly 2 brands? I mean, flying 2 brands is presumably possible, but was that in part of the evidence? Or?
So it's important to keep in mind, in 2014, Alaska wasn't on the scene at all. Alaska was just a hypothetical one of many competitor airlines out there who
Right.
might decide in the future to try to acquire Virgin America, and if they acquired it, they might decide to debrand Virgin America in order to brand it whatever else. It's not that Alaska were at all on the scene in 2014, and this
there
is
was no there was no competitive brand on the scene in 2014.
none at all.
Just the possibility,
The possibility-
of branding because of the new investors.
Exactly so, and also because, and this is important, a point of the factual matrix which the judge recorded in his judgment, Virgin gave up, in the context of the IPO, a series of important control rights which they'd had previously, which would have allowed them to block the sale of Virgin America, either its shares or its assets, to a competitor airline. They gave up those control rights as part of the IPO process. That is why...
They introduced the minimum royalty.
Indeed, as part of the 2014 agreement. And it's because they gave up those control rights that the parties would have been aware that it was now possible in the future that a competitor airline could come along. Virgin couldn't block them. And if they came along and if they acquired Virgin America, then they might seek to debrand at some time in the future. But none of that was... It wasn't on the table in 2014. Alaska didn't even feature in 2014. No reason why they would have done.
So they were busy flying in 2014 a relatively large fleet of aircraft internally in America that
Which
had
had
been
been-
built up since the early noughties.
Which had been built up since 2007, had successfully operated up to 2014, very successfully operated, and Virgin America was very much hoping to carry on in that way. And it's so much so that in the content, and you'll have seen this, and I was going to come to it later, but just to make the point now, one of the key things for Virgin America from the negotiation with Virgin in 2014 that led to this agreement was that they wanted to extend the term of the license. They weren't happy.
It came out to 25 years.
It was going to end in the one that was then current, the 2007 agreement, was going to come to an end in 2022 unless revenue thresholds were met and nobody expected them to be met, in which case it would come to an end in 2022. That was seen by Virgin America's bankers as being too short to make the IPO workable. They therefore negotiated for an increased license term.
And with an automatic extension of 10 years on top of the 25 years, I believe.
I don't think it was automatic,
Right,
but
anyway.
I think it could have been extended even longer.
Yeah.
That was something that Virgin America wanted, and as the quid pro quo for that, the Virgin Group, my clients, sought and obtained a minimum royalty guarantee to give them comfort that they would have a minimum level of income coming in over that longer term that Virgin America had bargained for.
So I'm not asking you to give evidence, but the other thing that's slightly I wanted to know is there's been no termination of this agreement. You're litigating tooth and nail, if I can put it that way, and have been since whenever this all began in 2019. But you could terminate, presumably.
Well, certainly we could,
Yes.
but there was very important evidence before the judge below, and which he accepted, and I'm going to come to that later in the factual matrix point, but there was evidence before the court, expert evidence, that there are huge difficulties in seeking to take back the rights and then relicense them to someone else. You either have to set up an airline at great cost with great delay,
absolutely
or you
sure.
have to find some other operating airline that wants the rights. This takes a long time and is very difficult. So you can't, in my submission, see a termination right as anything like equivalent to a guaranteed minimum stream of income. They're totally
I mean,
different.
I get all
Of course.
I just wanted to hear it so that my own preconceptions were not influencing the view. So 2 o'clock.
Thank you.
Thank you.
Call prize.